We're going to move on to the next portion of our webinar. Excuse me for just one moment. Sorry, some technical difficulties there. So we have two presenters today who are going to talk with us about zombie mortgages. And our first panelist is Andrea Bopp Stark. And Andrea is a senior attorney at the National Consumer Law Center in the Boston office. And she focuses on writing and teaching about fair debt collection practices and mortgage servicing and issues. Andrea is also involved in advocating for foreclosure prevention and fair debt collection policies on the state and federal level. And with that, I'm going to hand it over to Andrea to take it from here.
All right.
Andrea?
Hi, thank you, Ellie. You can hear me fine?
Yes,
yes,
hear you well.
Okay,
Thanks.
Awesome. Hi, everyone. I'm very excited to be here. A quick shout out to my Maine colleagues. That's where I am right now. I work in the National Consumer Law Center's Boston office, but I live in Maine. And I'm in my Maine home right now. And I'm very excited to talk to you about zombie second mortgages, because this is an issue that we're seeing on the rise with housing counselors all over the country and with consumer lawyers all over the country. We've been doing a bunch of trainings on it. We have some materials for you. So I'm going to get to it, but I do want to preface this with these slides are pretty chock full of information. I'm not going to go over them verbatim. I'm going to just use them as kind of a prompt, but feel free to go back and look at the slides after the presentation. So there we go. So what we'll cover today, we're going to go over what is a zombie mortgage, why did they occur, how did they come about, what's happening now, who are they affecting. We're going to go over what you all can do as housing counselors to help homeowners who are facing a zombie second mortgage. And then we're going to hear from Angella Davidson from Brooklyn, New York. She's a housing counselor there, and what she's seeing on the ground happening with zombie seconds. There are some resources here that you can click on our website about zombie second mortgages. We also have the NCLC manuals, if you have access to those. The Home Foreclosures manual is particularly helpful. We have a special chapter on second mortgages, chapter 12, that we wrote because of the zombie second issue that has been upon us. So what is the problem? For those of you who have had a client walk in the door and say, I have no idea why I'm getting this bill for this loan, and this loan was something I potentially took out years ago. I haven't heard from anybody in 5-10 years. What is going on? You have experienced the zombie second mortgage issue. So it's really an attempt to collect on these mortgages, these second mortgages that were taken out primarily in the late 1990s, early 2000s. And now these mortgage servicers, debt buyers, debt collectors are coming out of the blue to try and collect on them after not having had any communication with the homeowners for many years. And it's also an entity that the homeowner doesn't recognize. So it could be, ABC debt collectors saying you owe $100,000 on a loan that was originally just $75,000. And so homeowners might think this is a scam and somebody trying to collect money from them. And they may not pay attention until they're really up against a foreclosure. They often charge a lot more than what was originally taken out because they add interest and fees for all those years. And so the balance that is being asked of the homeowner is inflated, and the homeowner probably is in a state of panic and anxiety that they're going to lose their home. So where did these zombie second mortgages come from? So they originated, like I said, maybe the early to mid 2000s during the heyday of subprime lending. So subprime lending was lending to folks who didn't have the highest credit scores, couldn't afford or couldn't qualify for a prime mortgage at the going interest rate. So they were given these mortgages with higher interest rates, higher down payments, and part of the down payment process, many of these homeowners didn't have the 20% that you usually put down to purchase a home. So lenders came up with this scheme to provide what was called an 80-20 piggyback loan. And what that was is 80% of the purchase price was a traditional mortgage, and then 20% of the purchase price was this second mortgage. And that was used as kind of the down payment for the purchase of the home. So the homeowner didn't really have to put any money up front. And there were promises that, oh, the interest rate is high now, but if you pay your mortgage for 6 months to a year and you get your credit on track, then we'll be able to lower that interest rate for you. Of course, those promises never came to fruition. Many of these mortgages had adjustable interest rates. So after 6 months, a year, a couple of years, the interest rate skyrocketed. I mean, it was pretty high to begin with, 8 to 10%, and maybe it would jump to 12% or 15%, making it completely unaffordable for homeowners. And they also had early payment penalties. So if they tried to pay off this mortgage early or pay some of the principal early, they would face a penalty. And they had large balloon payments. So balloon payment is when there is part of the principal is put on the end of the loan in a non-interest bearing balance, so that when the homeowner eventually sells the home or refinances the home, they have to pay off that balloon payment at the end. And so they had some pretty predatory terms to these mortgages that caused borrowers to really struggle to keep up with the payments. And some homeowners didn't even realize they had a second mortgage. So if they were taking out an 80-20 loan and just signing all the paperwork here, sign here, all these hundreds of pages, and it wasn't explained, there weren't proper disclosures, they didn't even know they had two mortgages. And so they just continued to pay the first mortgage. So what happened is, after the housing crash around in 2008, as those of us who were working this field then know, housing prices plummeted. And so the values on homes just went down. And a lot of these mortgages became what we call underwater. And what that means is, if there's a first mortgage on the property, say for $100,000, and a second mortgage for say $50,000, and the value of that property is only $80,000, then both those mortgages are underwater, because even if you sell the property, it would only reap $80,000 as a price, and then only part of the first would be paid off. So second mortgages knew this. They knew that if they forced a foreclosure because the homeowner wasn't paying the mortgage, they wouldn't get any money. So the $80,000 would go to the first lien mortgage, and nothing would be left over for them. So they didn't bother. They didn't foreclose. They didn't even initiate a foreclosure or try to collect on this. What many of them did was, on their books, they charged the loan off. So that's kind of an accounting procedure where they charge off the loan for tax purposes, and they call it charged off. It doesn't mean the homeowner doesn't owe it. So that's really important, but they charge it off for their books, and they sold them. And so a lot of these loans were sold to trusts, securitized trusts, or debt buyers or debt collectors for pennies on the dollar. And so these mortgage holders, the servicers, the lenders, the creditors, they just went silent. And so they knew they couldn't foreclose and get paid. So they just kind of went silent and didn't send any notices. They didn't send any communication, and borrowers didn't hear from them for years. And so some common characteristics of these mortgages are They were underwater for years, so the value of the property was such that there was no value that would be provided to the second mortgage if they foreclosed. The mortgages were charged off on the books. There were no communications with the borrowers. So under consumer protection laws, loan servicers are supposed to provide a notice of change of servicing. The creditor or lender is supposed to provide a notice of change of owner of these loans. They're supposed to be providing monthly periodic mortgage statements to these borrowers, and they did none of that. A lot of these loans and lenders did none of that. And so why now? Why are they coming out of the woodwork now to try and collect on these loans? Well, the why now is because housing prices have increased so much. So the real estate market is back. Homes are worth more than ever. And borrowers whose homes were underwater now have equity. They have equity in the property. The second mortgage knows that that $80,000 house is now worth $250,000. So if they foreclose, the first is going to get 100 and the second will get their 50 plus interest and fees. If those aren't challenged, they'll get paid what they're owed plus potentially more. And so they're coming out of the woodwork now and trying to foreclose on these loans and trying to collect on these loans, because they know if the homeowner can't pay, then they'll get paid if they foreclose on the property and force a sale of the property. So what now? A lot of these homeowners have been paying on their first mortgage, and they have acquired quite a bit of equity in the property because they're current on their first mortgage. In fact, a lot of the debt buyers who are looking to buy these loans look to see if the homeowner is current on their first mortgage, and that's a draw because they know that those homeowners not only will have significant equity in the property, but they also will be desperate to save the property because they're current on their first, and they've been current on their first for years and years. Maybe they had a loan modification on their first years ago, but they've kept up with that. They've struggled, they've scrimped, they've saved, they've been able to keep up with that to save their home and keep their home. And now they're being targeted because they've been able to do this and been able to acquire some equity in their home. And so again, many of these borrowers haven't received any communications, any monthly statements, or anything for years. And a lot of them did get a modification on the first mortgage maybe 10 years ago. There was a program called HAMP that allowed many homeowners to modify their first mortgage. And there was a program called 2MP, which is for second liens back then for HAMP. And under that program, if the first was modified under a certain servicer and creditor, then the second would be modified as well. Well, that didn't always happen. Borrowers thought it might have happened. They thought either the second was included in the first modification, or the second was modified somehow or waived somehow. Several homeowners filed for bankruptcy during that time in a desperate attempt to save their homes, and they thought the second was discharged in bankruptcy. And so you combine thinking the loan was waived somehow with one of these government programs or discharged in bankruptcy with not hearing from the lender for 5 or 10 years, then a homeowner can reasonably believe that they don't owe this money and that this has been taken care of. And so that's where we are now. And that's why homeowners are so shocked now when they get a notice in the mail or served with a summons saying you owe tens of thousands of dollars on this second mortgage you've heard nothing about for many years. So who is affected? The CFPB is collecting complaints on zombie second mortgage. I would encourage you to definitely file a complaint with your clients, with your homeowners, if they have a zombie second mortgage. with the CFPB in their complaint database. So this is only through January 2020. I'm sure there are lots of more, but they had 600. And just what kind of things are homeowners complaining about? They are complaining that they received the collection notice or the foreclosure notice when they're current on their first, and that they thought the mortgage was charged off, meaning they didn't owe it. They didn't quite understand what that meant. Discharge in bankruptcy, or they thought it had been part of a loan modification. These complaints also show that homeowners tried to get in touch with their second mortgage holder at the beginning when they were falling behind, and then later on when they wanted to try and pay the mortgage, but they couldn't get in touch with the mortgage company or servicer. And that could be because these mortgages have been transferred and sold so many times that it's very hard to figure out who the current owner and servicer of these loans are. And some reported aggressive collection tactics where they were approached in person to repay the loan. They were told they faced imminent foreclosure if they didn't pay. They were added on interest and junk fees, and they were pressured to accept unreasonable loan mod options. So I've heard that quite a bit as well, where these servicers are willing to, negotiate, but the negotiation or the modification is $25,000 down, and then you have to do a repayment plan over 12 months, and then you can start paying your monthly payment again. And it's very unlikely homeowners are going to be able to afford that. There's also threats of negative credit reporting that would kind of mislead consumers and homeowners into paying these egregious amounts that the zombie second mortgage holders are demanding. So communities that are most affected, we see Black and Brown communities disparately impacted. These communities, Black, Brown, lower income communities, were targeted in the early 2000s with the predatory loans that I was talking about, the 80-20s, the adjustable rate mortgages. And so now these mortgages are coming back to haunt them. And elders are also disparately impacted by the zombie second mortgages, because it's been years since they've taken out this second mortgage. They've been current on their first. They have lots of income in the home or equity in the home, but they're on a very fixed income. So they are harmed by this because they really are not able to pay back that second mortgage. So how can housing counselors help these borrowers? So the first thing, and I've mentioned this already, is file complaints with the CFPB. So please, this is the link. If you have a homeowner, help them file a complaint with the CFPB so the CFPB knows what's going on and hears us and hears that this is an issue. The CFPB has this on their radar as an issue. There was a field hearing in Brooklyn, New York a couple of months ago where Angela and I were on a panel and we talked about the zombie second mortgages. The director was there. The Attorney General of New York was there. And so it was a great turnout and a very moving and powerful hearing. And so I feel like the CFPB is listening, but we need to keep on their heels. We need to keep telling them this is happening, this is an issue, and this is what's happening on the ground. So your complaints are really important. You can file complaints with your state's Attorney General's office. If your state has a Bureau of Consumer Credit Protection or something like that, you can file complaints there, or with the Better Business Bureau, and just be as detailed as you can about what's going on and who the bad actors are. Another thing, let me just take a sip of water, hold on. Okay. Another thing that you can do is send a letter to the mortgage servicer. And many of you probably are already doing this in some of your cases, but for those of you who are new to this, a qualified written request is the title of this letter that I'm going to talk about. And this is under the Real Estate Settlement Procedures Act, or RESPA. And a qualified written request allows a homeowner to send a letter to the servicer and get information about the loan, about how much they owe, get an account history so they can see, okay, this much is interest, and then these are the fees, and these are the charges, and this is the principal. Also, qualified written requests allow homeowners to assert errors and potentially have those errors in the accounts fixed. And it provides legal claims for attorneys if the servicers don't comply with the requirements of qualified written requests. And we're going to go through those. So Regulation X is part of RESPA. RESPA is the statute, and Regulation X is the, well, regulation. And so what constitutes a QWR? There are two types of QWRs under Reg X. One is to request information, and one is to alert the servicer that there's an error with the loan. Now, really important, if the servicer designates an address for QWRs, or a request for information is an RFI, a notice of error is an NOE, so all these alphabet soup of acronyms. But if the servicer designates a QWR, RFI, or NOE address, then the homeowner has to send the letter to that address. So look at the mortgage statement, look at the website, see if there is an address designated. For it to count as a QWR, it has to be sent to that address. And you want it to count as a QWR because then the servicer is held to certain requirements regarding the response of that letter. And so the letter also must include the borrower's name, information to identify the mortgage account, the information that you're requesting, or the error that the homeowner is saying occurred. If it's being sent by an attorney or a housing counselor, you should include a third-party authorization with that. A lot of times we help the homeowner draft it and then have the homeowner send it by certified mail, return receipt requested, so that we know when the servicer received the letter. And when they receive the letter, within 5 business days, they have to write to the homeowner saying, we received your letter. Then within 30 business days, excuse me, which is about 6 weeks, they have to investigate. They have to investigate what the error you're alleging is, or the information that you want, and provide a response. So you should get a response in around 6 weeks later. They can ask for an extension of that time, or tell you they're going to extend that time out for about 15 days. But that's the only additional time that they're allowed. So you should get, it's not an immediate response, but you should get a response within a 6-week period. So you want to get this letter out as soon as you can with your homeowner. If you're asking for a payoff statement or who owns the loan, they have to respond even quicker. So a request for information is one type of QWR, and you can request information that relates to the servicing of the loan. And so that's pretty broad. So for these zombie seconds, there's a lot of information you can ask for, and we'll go over some of it in a minute. But the servicer has to either provide that information, or after it's done a reasonable search, provide a written notice that they couldn't find this information, or the information isn't available, and what their determination is based on. And then they have to provide contact information for the homeowner to use if they need more assistance. And so that's really important to make sure you title it as a QWR and you send it to the correct address, so that they have to abide by all of these requirements. So what kind of information might you want to request, or the homeowner want to request, for a zombie second mortgage? So the current owner and servicer of the loan, like who owns my loan, who is servicing my loan, when did they become the owner or servicer of the loan? Also, the homeowner probably wants an itemized amount of what the servicer is alleging they owe. So they can look at that and see if the amounts are correct. And then you can ask for loan documents, any prior loan modifications. That might be helpful to show if potentially this second was modified at some point. You can ask for account transaction history. And then you want to ask for all communications that the servicer has had with the homeowner or that they have in their file from previous servicers and lenders, particularly the transfer of ownership or transfer of servicing notices and monthly statements. Now, these are really important because if the homeowner wasn't receiving any of these communications, then how were they to know how much they owed? How were they to know who to send payments to if transferring service? How were they to know how much they should send? So all of these are going to play into the story of your homeowner, the story that your homeowner took this loan out many, many years ago, had no communication with the servicer for many, many years, and didn't know how much they owed, didn't know it was increasing each month because they weren't given the proper disclosures. The whole point of these disclosures is so that homeowners can understand what they owe and budget accordingly and act accordingly financially so that they can pay these loans. But if they didn't have the amounts owed, then they wouldn't have been able to do that. So a notice of error is another important tool that you can use. You can have the homeowner send a notice of error if they think that the amounts alleged owed are incorrect or inaccurate. If the servicer provided misleading or inaccurate information to them, or there was some other error on the servicing of the loan or the account, the homeowner can send a letter saying, hey, you screwed up and this is what you did, and you now need to fix it. So in response to a notice of error, the servicer has to correct the error. So they have to conduct a reasonable investigation. And if they find an error, they have to correct it and provide a written notice saying we've corrected it. You were right, we screwed up. Here's a notice that we corrected it. Or if they do the reasonable investigation and don't find an error, which is what happens most of the time, they'll do, I don't know how reasonable the investigation is, but they allege to have done an investigation and found no error, then they have to provide that in a notice to the borrower and the reasons for their determination and the right for the borrower to request documents that the servicer relied on in making this determination. And again, they have to provide a contact for the borrower to reach out to if they have any questions. What can the borrower get if the servicer does not comply with RESPA? So this is important because if the servicer does not comply with these provisions of RESPA, the QWR provisions, then down the line, an attorney can sue the servicer and get actual damages, which could be interest or fees and charges. It also includes emotional distress for the servicer's failure to correct an error, for example, or provide adequate information for the borrower. There's statutory damages of $2,000 or up to $2,000 and attorney's fees and costs. So the borrower does not have to pay an attorney to bring these claims because it's a fee shifting statute, meaning that if the borrower wins, then the attorney will get paid from the other side. There is a statute of limitations on these claims of 3 years. So if you feel you have one of these claims, you want to connect with an attorney as soon as possible to deal with that statute of limitations. What else can housing counselors do? Well, you can consult with a bankruptcy attorney to pay back, either pay back the amounts owed, challenge the amounts owed, or surrender the home and have a graceful exit and discharge the debt and get a fresh start. So bankruptcy can offer an option for homeowners who are kind of at their last end and not sure what to do. So consulting with a bankruptcy attorney would be very helpful. Also, I like to advise housing counselors and advocates, attorneys to check the borrower's credit report to see if there's anything inaccurate on there regarding this zombie second mortgage. There shouldn't be anything on there because it's been so long, but if there is anything on there, make sure it's not inaccurate. Okay, and here are a list of legal resources and some links for you if you decide that you've done what you can for the homeowner, and now you want to assist an attorney to defend the foreclosure or bring affirmative claims against the servicer or lender. These are some websites where you can potentially find legal help for your client. I understand that a lot of you are probably not near a legal services office that has the resources or capacity to potentially take on these cases. But here are some other options that you can try, like NACA, our NACA is the National Association of Consumer Advocates. And there's a website there to find an attorney who's a consumer advocate who does mortgage work. And it doesn't necessarily even have to be in your state, because they could always connect with a local attorney to represent the homeowner in your state. So here are some options that you might want to look into if you don't have some attorneys that you know of that would be able to take the case. And I mentioned earlier our treatise, Home Foreclosures, and this is just a really great manual. I don't know if you have access to it. A lot of legal services organizations have access to it, and you may as well. And there's that whole chapter I said on the second mortgages. And so some other considerations I just want to go over briefly, things to just keep in mind. So there's both judicial and non-judicial foreclosure states. And so a judicial foreclosure state is one where a lender has to go to court in order to foreclose on the homeowner. A non-judicial foreclosure state, the lender does not have to go to court, and they can just send a notice and go through some types of requirements, but it's not judicial. They don't have to go to court. And so if you're in a non-judicial foreclosure state and your client is getting a zombie second mortgage statement saying you owe all of this money and we're going to initiate foreclosure, you're going to want to probably connect with an attorney if you can, to put a stop to that process, because in some states the foreclosure process can act very quickly, and from the initial notice until a sale date, that can be a very quick turnaround. And so if you're facing that, if you're in one of those states, you want to connect with an attorney as quickly as possible to try and stop that foreclosure. You also want to connect with the loan servicer, the lender, see if you can work something out with the servicer, a repayment plan or a loan modification or something that would be sustainable and affordable for the homeowner. But you also want to make sure the amounts are correct. So that's a big piece of this. If the servicer is claiming the homeowner owes $100,000 and the homeowner said, well, I only took out $50,000 initially, then you're going to want to double check that, look at the numbers, look at the accounting, see how much of that is interest, see how much of that are late fees or penalties. And I would say there's a very strong argument that any late fees or penalties should be waived. And there are arguments that even that interest should be waived. If they weren't sending notices, no communication for 10 years, then I think there's an argument under principles of unfair and deceptive practices that the lender and servicer should not be entitled to that interest. So that's something you can try and negotiate with the servicer and the lender, trying to get that interest waived, particularly if the homeowner could start making payments on just the principal balance. Maybe you can negotiate some kind of workout for the homeowner. In judicial foreclosure states, you're going to get, the homeowner is going to get served with a summons and complaint for the foreclosure. So they're going to have some warning. and they're going to be able to have a little bit of time to deal with that. And the slide that's up now is an introduction to the summary of state foreclosure laws. And so that's in our manual as well. And that will tell you if you're in a judicial or non-judicial foreclosure state and some of the protections that are available for homeowners in those states. Let me just see if I can go back for a second. Can we go back a slide? I'm not sure how to do that. Maybe Ebony can. Oh, there we go. Thank you. Okay, so time bar debt. I just want to raise this quickly, and Angela is going to talk to you about this too, because she's in New York. And so time bar debt, the CFPB came out with an advisory opinion saying that lenders, servicers who try and collect on debt that is beyond the statute of limitations in that state, it could be violating the Fair Debt Collection Practices Act. So it could be a violation of the FDCPA, which is a consumer protection statute that protects homeowners from abusive, harassing behavior by debt collectors. It could be a violation of that for a servicer who is also a debt collector under the statute to try and collect on debt that is time barred or beyond the statute of limitations. So in New York, the statute of limitations is relatively short. It's 6 years. Some states are 20 years, and other states are somewhere in between, and some have no statute of limitations on this debt too. But if you're in a state like New York or Washington that has a shorter statute of limitations period for this debt, then this is something you can use as leverage with the servicer to try and negotiate something for your client or for the homeowner. And you can negotiate saying, hey, you're trying to collect on this debt, but this debt is 10 years old and our statute of limitations is 6 years. And so you're beyond the statute of limitations. So once it's beyond the statute of limitations, they can't sue on that debt. To sue on that debt is a violation of the FDCPA, or to threaten to sue on that debt is a violation of the FDCPA. So if you're seeing that, I would definitely recommend connecting with an attorney, an FDCPA attorney, to figure out if that indeed is happening and what remedies the homeowner would have because of that. And then the Homeowners Assistance Fund, or HAF, which I'm sure you're intimately aware of, it can be used for zombie second mortgages as well. And so in states that are still accepting applications and where there's still funding available, don't overlook the use of HAF to bring these loans current or even pay off these loans as well. Okay, so that's all right, so now I am going to, I can answer questions and then we can go to Angela. Does that sound good, Ellie? Are there questions?
There are a few questions. And one of them you actually just answered about the Fair Debt Collections Act.
Okay.
So, but let's start with, so somebody's just asking what the statute of limitations for collection on the zombie mortgages, and are they essentially in the state that somebody is in, would they be the same as any other date in any other debt in that state?
So you have to look at secured debt, mortgage debt, and see what the statute of limitation is on that type of debt. And it is very state specific. So each state is going to be different.
And did you offer one of the links? Is one of the links a way for folks to find out what the statute of limitations are in their state?
It's in our home foreclosures manual in the appendix, if you have access to that.
Okay. But is there
you could Google it. You could Google it too. I mean, I do that a lot.
Okay, so just Google what is the statute of limitations in the state of whatever.
Yeah, for secured debt or mortgage debt.
Okay, great. Okay, all right. Can a second mortgage actually foreclose on a home even though the owner is current on the first?
Yes, and that's the problem with these is, and that's the horrible thing with these is, yes, the second mortgage can foreclose if they're not current. And then the first mortgage will have to be paid off. So in our original scenario, if they get $250,000 for the house in a foreclosure, that $100,000 first will have to be paid off, and then the second will be paid off after that.
And is the statute of limitations where the home is or where the lender is?
It's where the debt is, where the home is.
Okay. Okay, let's see. So somebody just is relating that a lot of the second mortgages that they see in this situation are ones where the homeowner had filed for bankruptcy and they were under the impression that the second debt didn't have to be paid when the file went into bankruptcy.
Yeah.
So then now they're obligated to, okay, so that at this point they are obligated to accept whatever the lender has to offer if they want to avoid foreclosure. I don't know if that's a question or a comment, but just talking about bankruptcy on a mortgage where now a zombie second is popping up.
Sure. So that we hear that scenario quite a bit, where homeowners were in crisis in the mid 2000s. They filed for bankruptcy to save the home. They got a loan modification potentially on the first, but if they filed a Chapter 7 bankruptcy, which is a total liquidation of all your assets, then that would have discharged the debt, but not the lien. So the lien would stay on the property. So the second mortgage can still foreclose on that if it's not paid. And so that's huge leverage by the second mortgage lender to try and get the borrower to pay, especially if they're current on their first and there's equity in the property. So they're taking advantage of this leverage to try and get homeowners to pay. But you want to make sure, like I said, the amounts are correct and accurate. And there may be some claims that could be raised to bring that balance down, like to get rid of the late fees and charges and costs and potentially some of that interest. So you may be able to get the balance down. You may, and after you do that, you may be able to get a loan modification for the person, but it really is at the discretion of the servicer, because we're not talking about Fannie and Freddie loans here or FHA loans on these seconds. So that's the trouble. It's going to be at the discretion of the servicer or this debt buyer who now owns the loan.
Okay. And I'm just going to ask people, I see some questions popping into the chat, and if people could put their questions into the Q&A so that I don't lose track, because otherwise I'm going to lose track of your questions if they're in the chat. Okay, so do servicers of second mortgages have to offer some kind of loss mitigation option?
No. So that's a problem. So servicers are supposed to provide certain notices at when the borrower falls behind on the loan. They can initiate foreclosure within 120 days of delinquency, all of this under the Reg X provisions. And if a borrower says, hey, I need help, they are supposed to evaluate them for loss mitigation options, but they're not obligated to provide any specific option. And so we've been seeing pretty egregious options of large down payments, very tight, expensive repayment plans, things that that borrowers obviously cannot afford or sustain. But then again, we're hearing about some decent loan modifications and some decent workouts for borrowers too. So it really depends on the servicer. Okay.
What if we think the investor bought the debt for much less? How can we negotiate?
You're probably right. These debt buyers buy these debts for pennies on the dollar. I mean, if you are working with an attorney, you can ask in discovery how much it was bought for and try and get that amount. But, other than that, it doesn't really provide any leverage. It does provide leverage in the overall story though, because if you're telling a judge, all of the facts of this zombie second, of the no communication, no statements, no letters for 10 years. Plus, they bought this $250,000 debt for $10,000. You know, I think it's part of the story, but I don't think it's really going to get you anything in the short term.
Could I just jump in on just a comment here? I mean, there's also the outside the judicial process things you could do. So you could go to a reporter and take some of the victims and say, these people have bought this pennies on a dollar and they're foreclosing on an elderly couple who has been in this house for 20 years, or it's a family with 3 children, and these outside investors have, are taking away from our community, and make it deeply uncomfortable, and that there's a publicity price, and to do things that kind of extend on that. And I would say then you bring in the, see if you can bring in your attorney general or others to come in on this, and local politicians. I mean, there's ways that you can start thinking about trying to leverage it beyond the judicial process, because these are such outrageous situations, and they're really stealing people's equity here. This is one of the ways that people lose.
Yeah, now that's a great point, Bruce, and I want to emphasize that. And there have been several very good articles on this issue in the Wall Street Journal and other publications. And right now, NPR is investigating this issue. They want to do a story on zombie seconds. I'm going to put in the chat, there's a survey on zombie second loans that if you are seeing zombie second loans, if you have a few minutes to fill out this survey, I mean, this is the heart of what we need for our advocacy. We need to know what the extent of this problem is. We need to hear these stories, like Bruce was saying, and get these to the CFPB, to the attorney generals, to people who can make some change on a policy level.
Great. So we do have some more questions, but I want to go ahead and give Angela the time to speak before we run out of time. So I'm going to take this opportunity to introduce Angela Davidson. She's the Program Director of Foreclosure Intervention Services at NHS Brooklyn in New York City. In addition to being a HUD certified housing counselor, she is one of only 7 housing counselors in New York State certified in reverse mortgage counseling. Her areas of expertise range from foreclosure avoidance, loss mitigation, financial coaching, and reverse mortgage to estate planning, training and development, and emergency preparedness and response. Welcome, Angela. Take it away.
Thank you, Ellie. Thanks for having me on today, and thanks everyone who is on today. Thanks, Andrea, for a great presentation. She covered a lot of the areas that I was going to cover, and the questions are, really on point to what we're seeing on the ground and the suggestions. So thanks for those great questions. I'm coming from the perspective of a housing counselor, what we're seeing on the ground, and what we're seeing on the ground and what we're doing, which Andrea kind of spoke of some of those things. So I'm just going to share 2 quick stories so that people, maybe in your state, you're seeing the same things. And as Andrea pointed out, these loans originally were originated somewhere between early 2000s and late 2000s. So the first story that I'm going to share is for someone who received her loan in 2006. She paid for 1 year, and then she fell sick and was in the hospital for about 2 years. So of course she couldn't make any payments. She received the modification in 2010 on her primary, and she never heard anything since 2007 on the second. In 2022, she received a demand letter stating that she was owing a mortgage. And she, for the life of her, couldn't remember that she had this second loan. She hadn't heard from anyone since 2007. Now, when she came to us, we did our intake, and we did our digging and made our discoveries. We found out that her loan was an interest-only loan, which matured February 1st of 2022. At that time when she got the loan, it was for $145,000. Today, July of 2023, she's owing $398,000 on that second loan, and her first loan, she's only owing about 280,000. So that outweighs the first. Lucky for her, they haven't started foreclosure action. We tried to get discoveries from the servicer, who told us they acquired this loan in 2018, so they have no timeline. We did the QWR, they sent us the payoff of the 398, but nothing on the history of the loan. Andrea spoke about the time barred portion. We're now working with an attorney because we do know that this loan qualified under the time barred statutes in New York. And so we're hoping that we will be able to get the time barred portion taken away, and then hopefully can get her on a payment plan. Second story, Mr. X received his loan also in 2006, and he received a modification in 2009. He thought that his second loan was a part of the modification and was included in that. He actually stated that his servicer told him that, because both loans were being serviced by the same servicer. And they told him that the modification modified both loans and he only had to make payments on one. Fast forward to 2019, he received the summons and complaint stating that he's in foreclosure and, of course, demanding payment on his second loan. Now, who are these people that are receiving these demand for the second loans? A lot of them, and I would want to say 99% of the ones we have seen in our shop are people who are seniors. They have retired, they have been paying on their first loan, they have acquired, their loans have, the homes have a lot of equity. So we stand to see millions of dollars of equity wiped away out of minority communities. And the reason I'm saying that is because these 80-20 loans affected minority homeowners more than any other homeowners. And so now that homes have acquired equity so much in New York, as Andrea said, the debt buyers, and who are these people that we're seeing? They are mostly law firms, some servicing companies, and a lot of private investors. And they have their private people who are doing the collecting. And so, they know that these homes have equity. And so they know that if they sue, the second will not prevent them, because being in first lien position, I'm going to get paid first. So, why will I stop you from going to foreclosure? And so they're allowing the lawsuits to go forward without putting up any defense. Back in 2012-14, when there was no equity, the first would not allow the second. We would always see them put in a defense. Now we're not seeing that, because of the equity. So we stand to see a lot of erosion of equity in households. What are some of the problems that we're seeing with people on the ground? So because people are retirees and on fixed income, they're not able to take on additional debt because their income is so fixed. So what is happening? We're seeing, because the summons and complaints are being filed, it's public knowledge when those things happen. So you have everybody out there knocking on these people's doors, telling them, we can help you, we can help you. So what we have seen, people are using their first mortgage money to pay attorneys to help them to address the summons and complaint on the second, which is then putting them in default on the second loan, on the first loan, sorry about that. Then we're seeing, the mental aspect of things happening, where people are just, being impacted, the stress of this. We had one client who actually, had a breakdown because she's a retiree. She has paid on her first mortgage for over 20 years, nearing the 30-year mark. And she's thinking, I won't have a legacy to leave for my children after all the hard work and after all the payments that I have made. So, she had that breakdown and ended up in the hospital because of the stress from that. We see scammers out there, right? So which is leading to a lot of theft in New York as well, because people know that people are in default. They come to their doors, they give them documents to sign. You don't know what you're signing. Oftentimes you're signing away your deed. And so we're seeing people losing their home, just not for the secondary loan, but from bad actors. So we really need to have better protections in place for these homeowners. What can housing counselors do? As you know, other housing counselors on the line with me, you know what we do. We're the first line of defense. And what are the things that we do? We help homeowners to create budgets. We help them to negotiate with their servicers. We help them to find resources. We help them to find attorneys. We help them to put the QWRs together to make sure that they get all the documents that they need, right? We need to understand the timeline of when this debt happened. Is it within the time barred portion? Although we're not attorneys, we're trained by our attorneys in New York, who's doing a fabulous job of dealing with these secondary loans and really helping homeowners to address them. So we know, like, for example, if something is 20 years, it might have a time barred portion, we don't know. What we do then is connect them with the attorneys in New York who are working on these secondary loans and helping them to get representation in the courts. So that is what we are doing as housing counselors, to help people to put things together to make sure that they understand how to get the QWR, how to, and then to help them to find resources. In New York, we're a little bit luckier than maybe some other states. We have the Homeowner Assistance Fund, which is closed now, but we have been able to use that Homeowner Assistance Fund to help a homeowner who had a second loan, to help them to pay off that loan totally. So that debt is now, they're now free and clear of that debt. The reason why we were able to do that is because her loan was probably $60,000 owed, but she had been getting correspondence. So the time bar portion did not come into play for her. But we were able to use half to help her. We also have another resource in New York, which is the Equitable Retention Mortgage Assistance Program, state specific, and we can help people to get as much as $50,000 to help towards a down payment on a second loan, to negotiate maybe a modification if someone's budget can afford that. And then we also have another resource called the Distress Mortgage Refinance Program in New York. If you're owing anywhere between $350 and $400, and your second can fall into that, they will refinance your loan to pay off the second. They will defer some of the first so that the refinance can happen and help people in that way. So as housing counselors, we help them to find resources. So maybe those are some of the things that you can figure out what's in your state. What can you help them with? Andrea spoke about bankruptcy. We also see our attorneys talking to homeowners about filing for bankruptcy because it will wipe out the second. It doesn't prevent you from continuing to pay on your first, but it will wipe out the second, depending on the circumstances. So that's one option that we're also using here in New York. Then the other thing, and this is just a recommendation, if you are not doing this, maybe to host monthly webinars on these zombie loans. We're doing that in New York with the attorneys because a lot of people don't understand zombie loans. They forget they have these loans. And then so when people are coming to collect, as Andrea said, they're thinking it's a scam, but it's really not a scam. It's a debt that is owed out there. Do you have to pay all of it? We don't know. And hence we're talking about time barred in these webinars. So the attorneys are really doing a great job working with us, boots on the ground. We're actually doing in-person events again. And so this is helping a lot of people in New York to recognize about these zombie loans and to understand what their responsibilities are and what protections they have under New York state laws regarding zombie loans and time bar debt. And thank you. That's just my presentation.
Thanks, Angela. I want to highlight that Angela talked a lot about coordinating and working with legal services and attorneys. I'm going to repost into the chat all the links that Andrea put together for us, where you can find what legal services might be available in your area. One of the things that we really did learn from the financial crisis is the importance of housing counseling and legal services working together to help homeowners, that when both are involved, that's when homeowners get the most get the most assistance is when both are involved. So I just wanted to highlight that. We have quite a few more questions left. We are probably going to go past 2:30. Andrea has said that she can stay on with us, so we are going to continue with the questions. All right, so and I do want to say, I think somebody just put this into the chat, but if you are not putting if you're putting questions into the chat, please put them into the Q&A box, because otherwise I won't get to them. It's kind of hard to keep track of them in the chat box, and I don't want to miss your questions. All right, so if someone already entered into a repayment plan on the zombie second because they were afraid of foreclosure, can they still complain regarding the lack of communication for years before the plan was set up and cancel the repayment plan for lack of this contact?
That is a toughie, because most likely they signed something saying they agree they owed this money. And if they signed something saying, yes, I owe this money and I'm going to pay it back in these monthly installments, that's going to be a hurdle. It's not an unsurmountable hurdle. I think, the right advocate or attorney could help with that, given the full story and how they were kind of coerced into signing that out of fear of losing their home. I think there's a story to be told, and there might be a way to get around that, but it's difficult, but I wouldn't give up.
And probably wouldn't hurt to see if you can get some legal assistance involved.
Yes.
Right, okay.
Yes, definitely.
Are there any HOAs factoring in as zombies?
So that's a good question. We haven't heard of the HOA zombie phenomena. I haven't heard of that, but I'd be very interested to hear about that if some of you are seeing that.
Yeah, so if anybody on the webinar is hearing that, please pop that into the chat box so that we know about it.
Another thing I did just want to point out, our HELOCs, or home equity lines of credit, those are popping up as zombies too. And I think those are still being made. These 80-20 loans are not being made still because of lending restrictions and guidelines put into place after that time period. But HELOCs are still being made, and you'll see them as zombies, but I think there could be another round of zombies based on HELOCs being made now. And so if people are taking out equity in their home now, and they stumble and fall behind, and then the equity is not there, housing prices go down, I think we could see the same phenomena happening again with the HELOC loan. So it's just something to be aware of and to keep an eye on, like Angela said, because this is here for a while. I think it's not just this one group of loans.
And do the statute of limitations apply to a bankruptcy scenario?
So I'm not sure what they mean by that, if the bankruptcy tolls the statute of limitations, or if I guess I'm not sure what they mean, but I would encourage them to speak with a bankruptcy attorney.
Okay. And what can the homeowner do if they were told the second loan was included in a loan modification with the first mortgage lender? It's been 15 years since a payment to second lender. It's now in foreclosure status for over a year. What recourse does the borrower have when the first is current?
Yeah, so everything we've talked about today, really, getting the information on the loan, using those QWRs to get the information about what is owed, who owns this, who has owned it, can they prove that they own it, who is the servicer, what are they saying is owed, you can even use a QWR to ask what loss mitigation options are available for this loan. And then you can see and ask them to be evaluated for that. And then getting the account history to find out if the amounts are correct, making sure the amounts are correct, see if there's any opportunity to decrease that amount based on junk fees, or, and by junk fees, I mean like home inspection fees and these fees that you can see on the transaction history that are just placed there automatically with no real substance behind them. And late fees and maybe even some of the interest could get waived to help get that balance down.
This person says they have a client that was told when they modified their first mortgage in 2009 that the second mortgage was dismissed. Is that possible?
Yes. And you wouldn't think so, but yes, there were government programs in place. There was the National Mortgage Settlement where the top 5 loan servicers were forgiving second liens. There was also, like I mentioned, the 2MP program out of HAMP, where if the first was modified, it was possible that the second would be waived. And so we've asked the CFPB to create a database of those loans. I don't know if they will or if they have the resources to do that, but to the extent that you can try and get that information from the servicer of the loan or the prior servicer of the loan, I mean, it would be helpful, or to the extent your client has any information related to that, if they've kept any notices related to that, that would be really helpful.
Okay. And this one, I think Andrea or Angela, or both of you could weigh in on this one, but what do you do when the second lien holder just won't negotiate?
Go ahead, Angela.
And so that is one of the things we're seeing, and I had left out my patterns. We're really seeing that within a lot of them are not willing to negotiate. So what we have done was use QWR in those, especially if we don't have a history, is to use the QWR to kind of stall them, to get information from them so that we can really see, if the time bar piece kicks in, if they have the right to collect and all of that, and then refer it out to an attorney to, I think sometimes when they get a letter from an attorney, they tend to want to fold and act better, even offering, to offer some kind of modification, albeit we're seeing very bad modifications. But that's what we have done when they won't negotiate, is to use the QWR. And then it stalls for a while. Sometimes we don't hear back from them for months. We had one that we did a QWR over 4 months ago, and we haven't heard back anything. Stalled out in the courts, nothing is happening with it.
Yeah, and I would also go back to what Bruce was saying on connecting with community activists and the press. And, if you have a really bad actor that has a pattern and practice of doing this, definitely letting state entities know, let the CFPB know, file those complaints. With the CFPB, if a homeowner files a complaint, the servicer is supposed to investigate and reply. And so that's going to provide you with even more information about what's going on.
Okay. Does the statute of limitation apply to the original date of the loan or the date the servicer debt collection purchased it?
Okay, so the statute of limitations for mortgages applies at the date of acceleration. And so that can be, you can apply the statute of limitations to each payment due, so when it becomes due. And so some payments may be beyond the statute of limitations where others are not, if it's on a payment by payment basis, or if the loan has been accelerated and the total amount is asked due, then the statute of limitations starts. And so that's one of the things you can ask in a QWR: has this loan been accelerated? And if so, when was the date?
Okay. Are there requirements that the servicer send monthly, yearly statements, or only that they notify the borrower when the debt is sold?
So the servicer is, so both. They're supposed to send monthly periodic statements to the borrower unless they fall into one of the exemptions. And they're supposed to provide change of servicing notifications to the borrower. So they're supposed to be doing both under the Truth in Lending Act and the Real Estate Settlement Procedures Act.
Okay. Are there caps on how much interest or fees the servicers can charge? And does it depend on the state regulations or rules?
the cap really is going to be, you can look in the note. If you can get a copy of the original note, that's going to show how much interest the lender can charge, and also any late fees that they can charge. But there's no cap per se. It would be in the note and mortgage.
Okay. I'm not quite, I think there's a word missing from this question, but does the first mortgage servicer have to be aware of the second, I think is what the question is? Or is this first mortgage servicer aware of the second mortgage?
So they should be aware because the second mortgage is recorded, but they may not be. They may not be because the first mortgage is recorded first, and then they may not check the registry of deeds for years and years and years, and unless the borrower is refinancing or selling the house or something like that. And so they may not know that there's even a second mortgage on the property.
Yeah, because there's some is a complaint that some of the ones we're seeing does not include the first as a defendant. So they're not notifying them that there's a foreclosure action going on.
And this question is for you, Angela. One of the housing counselors is wondering if you're willing to name the servicers that you have been having issues with. You're muted, Angela, if you're talking.
Yeah, I'm so sorry. So the one that I have right now is Loan Depot. And I don't even know if they're still in business anymore. So Loan Depot was that one servicer. And I had one with PHH, but they're willing to talk. So we're speaking now. Previously they weren't before we sent out the QWR. But Loan Depot is the big culprit where they won't even negotiate.
Yeah, we're seeing SLS, phase servicing, SN servicing, FIC servicing. So some of them that I had not heard of before this whole issue arose.
And I think some of the ones you spoke of, Andrea, are only servicing, especially the last one, they only service second loans, from what I heard and what we found out.
In default. Mm-hmm.
Yes.
Mm-hmm.
Okay, and then again, this is another question for you, Angela. You mentioned that what they're asking is, did you say that the time barred portion of the debt was forgiven? Can you explain that more, and which portion was time barred?
Well, not forgiven, but they cannot collect on the piece that is time barred. And is New York State, we said it's 6 years is the statute of limitation. So they can collect that first 6 years. But so say, for example, your 6 year ends in 2015. They cannot collect from 2009 to 2015, 9 and 6, 15, right? But they can collect after 2015. So starting 2016 to present, they can collect, but just not from 15 to 2009. If I understand it correctly. Andrea, you can correct me.
So they can attempt to collect, just to be, technical, because I'm a lawyer, but they can attempt to collect, but they can't threaten to sue or sue on the debt. So it's a technicality. I mean, they can still try and collect and get the borrower to pay, but they can't threaten to sue, or there's no real teeth behind it.
Oh, go ahead, Angela.
Because some of the communication we have seen also technically states that, right? That they don't use the term time barred. They use something that this thing is past something you don't have to pay it, you don't owe it, but they're still trying to collect. But they put that in, some of them put that in their communication, which is a good thing.
Yeah.
Just thinking about this, what you can do outside of the judicial process, especially with these smaller servicers that seem to specialize in seconds, it must be a pretty ugly business. You wonder who owns these companies, and that might be a pressure point there, that the actual owners, who might be a pool of investors, or more likely it's like a private equity company or some other institution, that this is a wholly captured institution, that they may be much more vulnerable to really bad publicity, which this should be.
That's true, Bruce. It runs the gamut of who owns these, and we are trying to do some more research on that. And that's one of the reasons that survey I posted is really important, to find out who is behind these. We've heard, the mom and pop buyer goes to this convention at a hotel, and it's a loan, a note sale convention. A group of firemen bought some of these notes and then tried to service them, and all the way up to the equity funds and secured trusts and the larger players. So it's hard to put a finger on it, but we're trying to get information on that.
Well, when you do, please let us know,
Yeah.
and we would put it on our list, and also I think the AFR list would be very interested in this.
Definitely.
So, this is somebody asking about when legal aid services are limited in the state that somebody is in. Are there other options? And again, I'm going to point to the chat where I put in the links that Andrea very helpfully provided us with, ways that you can look for other potential legal assistance. And then I think, I don't, not to throw you under the bus, Andrea, but if people have questions, they can reach out to you, I assume.
Yes, that's fine.
Okay.
Yep.
So if you pop your email into the chat, so people.
Let me see. Sure.
Okay.
So let me just do that first and see lc.org. And if you don't have a legal services office near you, like I said before, even if there's an attorney who doesn't do this kind of work, that's willing to serve as local counsel for an attorney out of state, you can go to that NACA, the National Association of Consumer Advocates, find an attorney website and try and find an attorney who does foreclosure defense, and see if they've done zombie second work, and see if they would be willing to help you out. If they can get waived, there's a process where they can still represent the person if they have a local attorney in the state willing to sponsor them. So, or co-counsel with them. So that's another way if you really don't have anyone in the state that can help out.
So there is somebody who's saying that they were kind of confused about the time barred thing. It almost feels like time barred issues could be a webinar in and of itself.
Potentially.
So I don't know if you want to try to get into that at all. It's just, is it the whole debt or just a portion? Yeah.
So with the example Angela gave, it was just a portion. So if the debt has been accelerated beyond, say the statute of limitation is 6 years, you're in New York, and the debt was accelerated more than, and they have to accelerate before they foreclose. So it was accelerated more than 6 years ago, then the statute of limitations has run on the whole debt. But if it hasn't been accelerated yet, the statute of limitations can run on each payment. So each payment beyond that is older than 6 years due is also time barred. That makes sense? Hopefully.
It makes absolute sense. Yeah. That there's a lot of math going on there.
Yeah.
And this person wants to know if a CFPB complaint can be used, and if it actually does work to spur a zombie debt servicer.
Angela, have you had any success with that?
Unfortunately, no.
Oh,
okay.
Yeah, I have heard that it's helped in other situations of mortgage servicing. I don't know if it's helpful with zombies, because the problem is they don't have to give a loan modification. There's no obligation to give a loan modification. So if somebody's complaining, I owe all this money and they're not working with me, and all they've offered is this repayment plan, well, unfortunately, that's all they have to offer. They don't have to offer anything.
Okay, so this is just a comment about the frustrations of this work. I have a client who even wrote her local Congress representative and the office responded, but no real action was taken. But fortunately, half was eventually approved. And somebody just, reiterated Loan Depot with an exclamation point.
Yeah.
I'm sorry, Andrew, you're going to say something?
I was just going to say, I think that's a smart thing to do, to write to your congressperson, your representative, your senator, and maybe CC like Elizabeth Warren or Senator Brown or somebody who really is involved in this issue and really cares about this issue. And I don't know if anything would happen, but at least it gets on their radar. And so the more we have that happening, maybe something eventually will change.
Oh, and the person who had the time barred question said, thanks, I'm less confused now.
Okay, good.
Only a little confused. That happens too to me. And it's maddening to think that we're using homeowners assistance funds to pay off these, basically predatory players in the market. Is there a sense that the CFPB, if there are things that the CFPB can do about this, if they take a regulatory action or an enforcement action?
Yes, there's a lot the CFPB can do, and we are pushing them hard on it. And we have a whole platform of what we would like them to do, but it includes all of that: regulatory action, supervisory action, enforcement actions, all of that. They definitely could do all of that. And so we need the stories, the data, the information, the complaints, all of that to keep pushing them to do something.
Okay, so there's a question here that with I'm not sure exactly what the term is that is being referred to, but I'm wondering if some SOLs, I don't know what SOLs.
Statute of limitation.
Oh, thank you.
Could have had different to me.
Could have had longer timeframes when the loan was originated versus what it could have been changed to more recently, or are those changes not really likely?
Well, the statute of limitations is set by state law. So unless the state law changed, then it wouldn't have changed.
Okay. And then, somebody had shared a link to the statute of limitations in Minnesota, which states that it is 15 years from the maturity of the whole debt secured by the mortgage. This person is assuming that there wouldn't be a case in Minnesota where part of the debt would be time barred since it is based on the date of maturity.
All right, what is that?
That's the statute of limitations.
There wouldn't be a case where part of it, right? Because it said, I don't know that statute very well, but just by it saying 15 years from the maturity of the whole of the debt, then that seems correct.
Okay. Okay. Let's see. So, okay, I would like some clarification on the time barred question. If they make a payment on the debt that is older than 6 years, does it reactivate the debt?
That's a really good question that we didn't get into. And it can start the statute of limitations going again. Like if the loan has been accelerated, it's tricky with in the mortgage context because, but in time barred debt in general, that can happen. And that is the danger of time barred debt. That's the danger of debt collectors continuing to try and collect on time barred debt, because if somebody pays, it could start the statute of limitations over again. But it's a little tricky with the mortgage situation.
And that is the last question.
Okay.
Thanks for hanging in there, Andrea and Angela. Really appreciate it. And I'm going to hand it over to Bruce.